Hey, good afternoon, everyone. Thank you for joining us at a Prestige PEO webinar series. My name is Carrie Kaiser. I'm the Marketing Operations Manager at Prestige PEO, and I'll be your host this afternoon. In today's session, we'll focus on key compliance updates impacting the Northeast region. Just a quick heads up, we'll be hosting additional webinars over the coming months covering other targeted regions. I'm pleased to welcome back Elizabeth Shaw, Chief Human Resources Officer, and Carrie Pilon, Associate General Counsel and Senior HR Consultant, who will be leading in today's discussion. All participants will be muted by default, but please feel free to use the chat feature to send us your questions at any time. We do have a lot to cover today, so if we're not able to get to every question during the session, a member of our team will follow up with you after the webinar concludes. And then today's webinar is being recorded and will be available on our website at prestigepeo.com/webinars for your reference at any time. And with that, I will turn it over to Liz and Carrie. Welcome, ladies.
Hi.
Thank you so much for that intro, Carrie. We appreciate it. We're excited to be back for our first webinar of the year, where we're talking about all these fun employment updates. And, it's our pleasure to do this. Carrie and I are really passionate about what's happening in the workplace and making sure that our clients are in the know as to what's going on and what they need to be doing to stay compliant. So today we are going to be covering legislative and compliance updates for our Northeast states that are listed on the slide. We're also going to be talking about some key case law developments that we want you to be in the know about. And then we're briefly going to talk at the end about just some employment trends and hot topics that we are going to continue to see into 26. A lot of these will not be a surprise to you if you've been following our webinars for any length of time, but it's always good to know what's coming on the horizon. So before we dive into the details and get to the really good content that we have for you, we of course like to give our disclaimer. We are here today to give you some really great information from an HR perspective. We are not here to give legal advice. And we are also not here to take any kind of political stance on things, although there is a lot of things that happen in the workplace and in our country right now that is politically driven or influenced. Of course, we are here to present the facts as they are and the law as we are navigating it, no matter what administration is in charge or whatever the case may be. So we, of course, encourage you before you take any action based on our advice or our conversations today to make sure that you consult with legal counsel. We are here to help and certainly help you stay compliant. So we are ready to get into that with you all today. So thank you for indulging me with my disclaimer. And let's kick it off and talk about our New York legislative and compliance updates. And Carrie, you are going to start us off strong with our first topic.
There are a number of things we want to touch on today in the state of New York as well as New York City. And certainly we did just do a comprehensive New York employment law update webinar back in December that is available for viewing. But since that time, Liz, there have been a number of additional changes that we want to make sure everyone is made aware of. There were a number of bills that were sitting on the governor's desk that were awaiting her signature. Those weren't addressed until approximately the third week of December. So around December 19th, the governor did finally sign some employment-related legislation that we're gonna kick it off with today. The first is it's been coined the Trapped at Work Act. This particular piece of legislation particularly prohibits employers from requiring employment promissory notes. So effectively, what this bill is doing is it's codifying existing case law that prohibits the stay or pay provisions in the employment setting. So it was signed into law on December 19th, and the effective date was immediate. So it really does define, so immediately upon signing, these became prohibited. And it defines a promissory note as any instrument, agreement, or contract provision that requires a worker to pay the employer any sum of money if that employee leaves that employment arrangement before a predetermined time. So it would be reimbursing the employer for requiring them to, if there was some sort of financial arrangement that was set forth prior to that. So included in the definition is any payment of money that represents that reimbursement for training provided to the worker by the employer or third party. So that's really key here is that training piece. There are some exceptions, certainly to the Trapped at Work Act, but they include sums advanced to the worker, again, except for those involving training, and payment to the employer for any property sold or leased to the worker. And then there are the agreements requiring educational personnel to comply with the terms of a sabbatical leave. So again, Liz, this is really prohibiting employers from requiring these promissory notes as a condition of employment. And a penalty associated with this would be a fine of not less than $1,000, but not more than $5,000 for each violation. The legislation does not necessarily cause a private cause of action. It doesn't give a private cause of action, but if an employee successfully defends against a promissory note agreement, then the employee may recover attorney's fees. So.
Right. So I think that this is a good one for our New York employers to be aware of, because a lot of them do different kind of training arrangements and definitely want to invest in their employees and help them grow, but they also want to see that return on investment. So this act is really putting some boundaries there for employers, and really allowing employees the freedom to leave a job if they would like to without a financial penalty ultimately. So definitely an interesting law that was passed and is now in effect. But that's not all New York has been up to.
We have a couple of more. We now have in the state of New York a prohibition against credit check. There's a limitation, I should say, against credit checks and for employment purposes that will now mirror New York City's. So effective April 18th, employers, New York State will join New York City in significantly restricting employers from requesting or using consumer credit histories of applicants or employees for employment purposes. So again, a consumer credit history is any information obtained through a consumer credit report or credit scores, or from a third party or directly from an applicant or employee that are detailing credit account, credit history, bankruptcies, liens, judgments, things like that. So it is, it's communication that involving an individual's credit worthiness, their credit standing, capability, and history, certainly. So again, there are some limited exceptions to these prohibitions, and specifically job positions that by law, regulation, or self-regulatory organization require the use of an individual's consumer credit history for employment purposes would certainly allow that type of credit check. Additionally, there's law enforcement positions subject to background investigations by state agencies, positions that require the employee to be bonded would also obviously be allowed. Positions requiring security clearance under federal or state laws included in this list. Non-clerical positions that involve regular access to trade secret or national security information, and certainly positions with signatory authority or fiduciary responsibility over third-party funds or assets valued at $10,000 or more, and positions with regular duties that allow employees to modify digital security systems established for security purposes. So again, there's a number of carve-outs to this very limited exception.
Right. And obviously, I think those carve-outs are very clear that, if there is a legitimate business reason for it, certainly there are some exceptions here to allow employers to protect their business from those who may not be the best financial advisors or the best people making serious financial decisions for the company. But this does go into effect in April of this year, so it is coming up. There's a little bit of time. And just to reiterate, we do, at the end of our webinars, we do share this content online on our website, usually within 24 to 48 hours. So if you have any questions about the content that we're going over today, you are more than welcome to look at our website and be able to reference this material. And of course, we're always here to help as well. If you have questions, reach out to your HRBP or, reach out to someone else at Prestige and we will get you the information that you're looking for. So this, I think, is, I understand this law, and I think that it's a good balance between protecting the employees from being turned down for a job that they, very well could need based on their credit history versus, legitimate employer reasons. So that was the credit check limitations rule that's now in law. But we also have some codification of another concept that actually has been around in New York for quite a long period of time. And that is the disparate impact theory of discrimination. And so, again, this was one of those things that was passed into law just last month in December by the governor. And what it does is it amends the New York State human rights law to actually codify, so put into law, the disparate impact theory of discrimination. The state has had this position for a while, but now we have the law actually stating it to back it up. So what exactly does this new law say? It says that it establishes an unlawful discriminatory practice may be established by a practice's discriminatory effect, even if the practice was not motivated by discriminatory intent. So at the end of the day, even if the purpose of whatever it is the organization was doing or its employees were doing was not meant to be discriminatory, but that's what it ends up being in practice, this is saying that is enough to make it unlawful. So this kind of takes away the intent behind the actions. It kind of just looks at what the fallout of those actions are. And this is going to apply to all cases alleging employment discrimination occurring on or after December 19th, 2025. So I think to just keep in mind that this bill does not specifically specify where the law applies to all pending claims. So, I don't know if they're going to retro, apply this to anything, but, certainly we're looking for some clarity from the state given this new codification, and, ultimately we'll see how they end up implementing this law. But it's a good thing to know that it's there. And recently I was talking with a client about their handbook and about their policies, and we were talking about discrimination. And I think that this is just another reason why you want to really have a strong policy in place against discrimination in the workplace, because ultimately the fallout of what has happened is really going to be what the state is looking to, not the intent behind it. So Carrie, I don't know if you have anything more you wanted to add to that.
Well, we had talked about kind of a practical, like what types of policies, right? Everything
Right.
from dress code, scheduling, observation of holidays, various different policies that employers may have on hand could be determined, could potentially, fall under just a reevaluation of those policies to see if the disparate impact is something that they need to be considerate of, certainly.
Right, absolutely. And thank you for that. So New York State was, busy with some new stuff, but New York City is never to be left out. And so in this case, they have expanded the sick time law that New York City has. So the New York City Earned Safe and Sick Time Act, I will hereinafter try to refer to it as the ESSTA. I do find that acronym to be a little bit tricky for me to navigate, so forgive me if I mess it up from time to time. But basically, what it is traditionally it has been sick and safe time that is provided to employees, which is up to 40 to 56 hours of paid leave per year. Based on employer size, for the prevention of and preventative care for illnesses and for certain safe time reasons like stalking or domestic violence. So it's supposed to cover a variety of reasons. And there are definitely some updates that have taken place to the law that we want you to be in the know about. So the first thing that has changed is it has been some expansion of what is available to employees to use. So in this case, there is a new unpaid leave requirement aspect of the paid sick leave. And in this case, it's going to be 32 hours of unpaid front-loaded time at hire and each year thereafter. There's no carryover of it, and it is immediately available to employees upon hire. It is going to be tracked separately from your ESSTA paid sick leave, because this is only going to be, these 32 hours are only going to be unpaid. And in general, you're going to default to requiring or having your employees use their paid time first, and then use this 32 hours of unpaid time after they've exhausted their paid sick time. However, employees can ask to use their unpaid time first. And if that happens, then you are going to need to let them do that. So they've also expanded the reasons why people can use the leave. So now it can be used for the care of a minor child or care recipient, housing and benefit proceedings, applying for things like shelter or other helpful benefits. Also, workplace violence, can be used, as well. And then, interesting public disasters like workplace closures, school or childcare closures, and other official stay indoor or travel orders. So this makes me think of our friends in New York who are experiencing, and the, Northeast, who are experiencing some rather intense northern weather. We hope you all are staying safe and warm. But certainly, I think the intent of these changes is to give more resources to employees as they navigate some more delicate or trickier times that just happen in life. There are some record keeping and pay changes, though. So, Carrie, are you gonna
Yes.
let us know what those are?
Absolutely. So with the effective date of February the 22nd, these requirements are right around the corner. So certainly each pay period, employers are required to show on pay stubs, pay statements, if you will, a variety of different things. In this particular, with this example, the sick and safe time accrued, the sick and safe time used, and the sick and safe time available is part of that pay stub requirement at this point. So the coverage applies to both paid sick and safe time as well as that bucket of 32 unpaid hours you just spoke on. So both of those need to be reflected on the pay statement or equivalent written document. So again, employers are encouraged to ensure their HRIS and payroll systems can track and display the separate balances and recognize what that defined calendar year is for your earned sick and safe time
Right.
allocations. So
Absolutely. And of course, here at Prestige, our payroll systems are prepared for these types of changes and to make sure that all the pay statements are up to date and accurately reflect the content required by each individual state. As a reminder, though, this is a partnership with our clients. And so if you have people using their sick time, you're giving other benefits or whatever the case may be, making sure that that information is communicated to us, tracked accurately, will help ensure that those pay stubs and records are in line and showing that you guys are in compliance. Additionally, there is some documentation and confidentiality updates as well. So from a documentation point of view, for sick time, if you have 3 consecutive days where people are out for sick or safe time, for the sick time specifically, you can ask for documentation from a licensed healthcare provider. However, if there is a cost to the employee for having to obtain that documentation, you, the employer, need to reimburse them for it. So, it does allow you to substantiate the need and why they've missed, so many days, but they want to make sure that there's no negative impact then on the employee for having to produce that documentation. That's the same thing for safe time, only we're looking at a broader spectrum of different documentation that can be produced because the safe time can be used for a variety of reasons. So you may still ask for documentation, but it could come from a broader range of sources, such as legal and social services providers, school or care providers, an attorney. It could come from police or the courts. So it's just good to recognize that even if you're not familiar with the organization or governmental authority who is reaching out and providing this documentation, that there is a lot of room for employees to be able to comply with what they're producing in these cases. So if you have questions, reach out to us. But by and large, this is what employees can produce to establish that they can use their safe time. Same rule here. If you're going to ask for it and it's going to cost the employee, you're going to have to pay for it. So keep that in mind in terms of reimbursing your employees for any documentation they have to pay to get a hold of. The other thing we want to highlight is confidentiality. Employers may not require the employee to disclose the underlying reason for using the safe and sick time. So they don't have to do it. So just remember, once they're past the 30 days of being out sick, yeah, you can ask for that documentation to substantiate the need for it. But just remember that on the front end, you are not going to be asking them to disclose their issue. Any information you do obtain, because people like to share, or you may get documentation, within the parameters of the law, just keep in mind it must be treated confidentially, and it can only be disclosed either by the employee, with the employee's written permission, or as otherwise required by law. So I think some common sense things there, but just know that they're in the law, and we want to make sure that we're respecting the boundaries of the employee's privacy as provided by this law. All right, so Carrie, we also have some paid prenatal leave that has been incorporated as well into the ESSTA. They were busy this year with expanding it. So just when I think I'm done talking about it, I remember, there's just a little bit more. But ESSTA now formally incorporates 20 hours of paid prenatal leave into the law. So what does that mean? It was only previously in the guidance and regulations, but now it's actually codified in the law. So employers have to provide 20 hours of paid prenatal leave in addition to the paid sick time the employee is already entitled to and the 32 hours of unpaid sick or safe time. There are some exceptions to this. If you are in a union and you have a collective bargaining agreement, the CBAs can waive the ESSTA if they provide superior or comparable benefits, and unpaid time off cannot be treated as comparable for this paid prenatal leave. So definitely a lot, going on here. And of course, there's always that enforcement and penalties that we also want to be aware of.
There's always the enforcement mechanism, certainly. So what is the employer's risk?
Yes.
The Department of Consumer and Worker Protection can now grant expanded relief in the form, of course, of penalties, because that's ultimately the enforcement mechanism that's generally used in this situation. So if there's a finding of underpayment of sick or safe or paid prenatal leave, it is either 3 times the wages that were denied or $250, whichever is greater, denied, conditioned, or interfered with the use of sick, safe, or paid prenatal leave, including requesting replacement workers or extra hours without mutual consent, is deemed to be a penalty of $500 per instance if a finding of that is found. Retaliation. So if it's a non-termination type of retaliation, there would be full lost wages or benefits plus $500 plus equitable relief. If the finding was an unlawful discharge, it would be full lost wages and benefits plus $2,500 plus reinstatement or equitable relief. So we have both past and future potential wages where, if it's a retaliation and non-termination, it certainly could be what's identified there, including past wages. So for policy violations, official or an unofficial policy not allowing the use of sick or safe or prenatal leave, that would be $500 per affected employee. And then notice violations is up to $50 per employee for failure to provide the required notice under state law. So with these particular, city law. So with these particular situations, it's really important to understand that, when a penalty is identified or a finding of a potential violation is identified by the department, then oftentimes those, there's not just one finding. Those can tend to snowball because they'll find additional issues. So it's really important from a compliance standpoint that employers understand each and every one of these and the related, enforcement or risk, if you will, for non-enforcement, non-compliance, I should say.
Absolutely. So what can employers do? There are definitely some proactive steps you can take to be in compliance. First and foremost, update those handbooks and policies to add the 32 hours of unpaid sick and safe entitlement, incorporate the expanded uses, include your prenatal paid leave provisions, and update that confidentiality and documentation language. So we can help with that here at Prestige, updating your handbook for 2026 to incorporate these changes. Also, here at Prestige, again, when we're talking about payroll and HRIS configurations, making sure that you have your paid sick leave set up properly, that you have the 32 hours of unpaid sick and safe time set up as well, which goes into effect shortly here, and the 20 hours of paid prenatal leave as well. And so you're going to want to ensure that your pay statements are showing the accrued, used, and available time as well. And like I mentioned before, our systems are set up to display that data, but also we need the cooperation from you guys as well to make sure that we have the most accurate information for how you have your policy set up and how you're using it. And then the other side of things that I think sometimes gets missed just in the shuffle of everything is making sure that your managers and your supervisors are up to date on how to handle ESSTA requests. So knowing what they can and can't ask for, knowing when documentation is appropriate, and really respecting that confidentiality that the employee has. So these are all proactive things that employers can do to set themselves up for success. So that was a lot for New York. So Carrie, take us through New Jersey and what is happening there.
Yes. So heading to New Jersey, we want to highlight the changes associated with the Family Leave Act. So the New Jersey Family Leave Act is the current act that allows eligible employees to take 12 weeks of job protected leave per year. And it really is to bond with a newborn baby or to care for a family member with a serious health condition. The effective date on this one is July the 17th. And currently it applies to employers with 30 or more employees. But as of July of this year, it will the employee count will be reduced to 15 or more employees. So obviously it's expanding the eligibility of workers in New Jersey. By 2027, that will be 10 or more employees. And by 2028, July of 2028, it will be 5 or more employees. So the current requirements for an eligible employee to be eligible for this leave is an individual who's been employed for at least 12 months by their employer and worked at least 1,000 hours in the 12 months preceding the need for leave. So what are the changes? The changes, and I'll get back to job restoration in a moment, but the changes are critical here because an individual now has to only be employed for at least 3 months by their employer and worked at least 250 hours. Now the look back period is a little bit inconsistent. It's either a 3 or 12-month look back period for the preceding the need for leave. And the reason I say it's inconsistent is because this is such a recent change, such a recent amendment, that the law was published one way and the governor's press release published a different look back period. But they do expect these to be worked out and resolved before the effective date. So certainly that look back period and all of the, how it actually has been enacted into legislation will be certainly worked out prior to the effective date. Now, as far as job restoration, this is a job protected leave, which is important to understand because it really requires employers to restore employees who take temporary disability or family leave insurance benefits to the position or equivalent position of similar seniority, status, benefits, etc., where the job protected status may not necessarily apply to the family leave insurance benefits, etc. This is now saying the leave taken under New Jersey Family Leave Act is otherwise requires job restoration. Another piece to this is that employees have the right to choose their leave benefits. So if the employee is eligible for New Jersey earned sick leave and either temporary disability or family leave insurance benefits, the employee reserves the right to select the order in which these leave benefits are taken. So again, it's a little bit complicated, and we encourage you all to reach out if you have questions so we can help navigate.
Right. And we do have a great leave of absence team that can help with the nuances of what should be applying when, where does the employee have that flexibility, so that you can get them the appropriate leave for the appropriate situation. So let's move on to Connecticut and talk about what's happening there. And I think the theme of today's presentation is either sick time or paid leave changes, because that is one of our hot topics and has been for many years. So we continue to see states like Connecticut make changes to their paid sick leave. So effective already January 1st of 2026, there have been some changes to Connecticut's paid sick leave. And first and foremost, we're going to see it expanded as to which employers it applies to. So before it applied to employers with 25 or more employees, now it's going to apply to employers with 11 or more employees. So that really drops it down and makes it really apply to a wide a number of employers. So you want to make sure you understand that drop. Also, you want to know that it applies to all full-time and part-time employees, with some limited exceptions when it comes to seasonal or unionized construction workers. Interestingly enough, you cannot require employees to find coverage or replacement in order to take sick leave. So we've seen that in other instances. So again, the goal is not to make it overly burdensome for the employee if they need to take the sick leave, by making them find someone to cover for them. So I think that's one that sometimes we overlook as employers when we're scrambling to get things done, but just know that they're not required to do that. And then record keeping must be kept for at least 3 years, which I think is pretty standard, but again, a good reminder that you want to have good records in place, good corporate hygiene when it comes to tracking your paid sick leaves. There's also been some additional amendments where we again see the family member definition get expanded, in this case to include siblings, grandparents, grandchildren, and some others. And also now this leave can also be used for public health emergencies and exposure to communicable diseases. So we continue to see states take it upon themselves to have these sick leave policies in place, to assist employees in being able to take care of themselves and their health, and also their family members as needed. So what else has Connecticut been up to? They have made a change to their minimum wage. Last year it was $16.35. This year it is $16.94. There has been no change though for our tipped employees, but we are expecting some in 2027. So Connecticut was pretty quiet this year, other than their paid sick leave changes and the normal minimum wage updates. And Maine as well typically is pretty quiet, but Carrie's going to talk to us a little bit about Portland in just a minute. But for now, just keep in mind there were some salary threshold increases in Maine. Last year it was $845.21 per week for executive, administrative, or professional exemptions, and this year it is $871.16 per week. So that is a slight increase. Minimum wage went from $14.65 to $15.10, and our tipped employees went from $7.33 to $7.55. So those are just some things to keep in mind. But Maine had its capital be a little bit busy here. So Carrie, talk to us about Portland.
And we do see this in a number of different states where we have local jurisdictions that have additional minimum wage requirements, such as in New York City, et cetera. So this one was a voter initiative. So it's the third time in 5 years that Portland has attempted to increase their minimum wage by getting this on the ballot. And this past November, it was successful. So again, it was instituted by a citizen initiative. So the minimum wage as of January 1 has increased to $16.75. Next January, it will be $17.75, ultimately landing, and this is a 3-tiered approach over 3 years, at $19 an hour on January 1st, 2028. This also impacted the tipped wage. So we do have an increase there as well. So the tip minimum wage is $8.38 an hour. With the employer must meeting the 1675 when combined with tips. So there's that difference there that needs to be made up, if you will.
Right. And my geography teacher from probably elementary school would remind me that Portland is not the capital of Maine. However, it is one of their biggest cities.
Yes.
So, and they definitely have some active voters there, busy keeping things up to date. So on the Massachusetts front, we have a couple of changes again to paid family and medical leave on this front. In this case, we have a weekly benefit increase from $1,170.64 to $1,230.39. So there's not going to be any changes to the contributions that are made for 2026, but there is going to be some requirements that you update your posters, your notices, your rate sheets, and any other private plans that you may have to reflect this updated information. So keep that in mind for Massachusetts, but not to be left out, New Hampshire has been, I think, pretty active this year. So I'm going to kick it off by talking to us all about unpaid childbirth related leave. So this is new. It just went into effect January 1st of 2026. So New Hampshire's unpaid job protected childbirth and pediatric appointment leave. So it covers a variety of things here. But it's going to apply to employers with 20 or more employees. Please note, employees can use it from day one of their employment, so there's no minimum service requirement. This is, interestingly enough, job protected leave, which I have to say, I think Carrie and I were talking about this earlier. We don't typically see job protected leave for this type of leave. It's usually our longer, more complex leaves that we see. But on this front, New Hampshire really wanted to make sure that their employees were allowed to take advantage of this without fearing losing their jobs. So they're allowed to take up to 25 hours of unpaid leave within the first year following childbirth or adoption for medical appointments related to postpartum care and for the care of their new child. When both parents work for the same employer, the 25 hours can be divided between the two employees. But please note that employers can request advance notice of the need to use this leave. So that is a good thing for employers. So what should employers do to stay in compliance? Again, they want to take a look at those handbooks and policies and make sure that they're up to date and in compliance. They also want to make sure the supervisors and any other staff are on notice of the requirements and any documentation procedures. You also want to implement a tracking system to make sure that even though this is unpaid leave, that you can show that the employee was given it should you ever be questioned by a government agency. And then you want to make sure that supervisors are able to recognize qualifying requests and job protected leave requirements. So I would just keep that in mind. This one is a little bit of a nuanced one just because of the job protection, but it's definitely one to be cognizant of. So with that, Carrie,
And
what's
it
happening
does.
with
Yeah, another leave that New Hampshire has implemented it from a legislative standpoint. Again, job protected leave. That it's important, a takeaway for both of these certainly is training management to understand and recognize when these leave requests come in. What applicable legislation may apply. But again, effective January 1st, we have military spouse leave. So this does apply to employers with 50 or more employees at a single New Hampshire work site or work location. And this applies when an employee's spouse is serving in a military branch and they're mobilized for up to 1 year and 1 day. So it can be for purposes of war, national emergency, or contingency operations. So that spouse is now covered with that job protected leave as well. So to Liz's point on the last slide, reviewing and updating policies to account for this. Also establishing and training supervisors on the documentation procedures related to this, to verifying those mobilization orders, et cetera, really understanding what they're looking for when an employee comes to them with this type of request. and really ensuring that those supervisors and managers are recognizing these qualifying requests and reasons for this job protected leave.
Right.
So,
Right. And then New Hampshire has had a veteran hiring preferences law in place, but they've made some changes to the current law. So effective this month, they have expanded it to allow employers to, from my understanding, voluntarily permitting them to give hiring preferences to military associated applicants. And that wording is very specific because we have a variety of people who can fall under this law now. It's not just going to be your veterans, but it can also be veteran spouses. And it can also be all active duty services, regardless of the length of service. So anyone who's serving, they can be given preference as well. So, our same kind of, spiel that we've given on the past couple of slides applies here, in terms of making sure that even though it's called the Veterans Hiring Preferences, that you guys understand as employers that it's much more than that now, and it really encompasses any military service or veteran spouses as well. So you want to make sure your employees are in the know on it, and certainly those who are in authority over them. So that was New Hampshire. They definitely had some interesting changes to their laws this year. Pennsylvania has also been keeping up with the times, and starting us off, Carrie, talk to us about the Crown Act, because we've seen this
yes,
in a lot of states,
we
and
have.
Pennsylvania's finally on board. So
Yes,
talk to us
yes.
about the Crown Act.
So Pennsylvania it's by no means unique, if you will. More than 20 states and cities have adopted Crown Act style protections. So specifically, Crown stands for creating a respectful and open world for natural hair. And it's already recognized protection in its guidance under the Pennsylvania Human Rights Commission, but this is really, it's legislation that's now effectively codifying this as well. So it applies to employers with 4 or more employees in Pennsylvania, and it amends the Pennsylvania Human Relations Act definition of race and religious creed and prohibits discrimination based on hair types and styles that are associated with race and head coverings associated with certain religions. So race, the definition has been expanded to include traits historically associated with race, including hair texture and hairstyles. And the examples given are locks, braids, twists, coils, bantu knots, afros, and extensions. And religious creed includes head coverings and hairstyles historically associated with religious creed. So there are some, obviously there's some limited exceptions that are carved out that employers can consider.
That's right, Carrie. And those would be your valid workplace safety and health concerns, or other bona fide occupational qualifications. And in order to establish that you can use an exemption as an employer, there are 4 requirements that you need to meet. 1, a health or safety risk would exist without the rule. The rule is adopted in a non-discriminatory reason. The rule specifically addresses the position or activity, and it is applied equally to all individuals in similarly situated roles. So obviously the goal here is to be equal and fair across the board in any kind of rules restricting any kind of hair or hairstyle. What employers should do: review your grooming and your dress code policies, and make sure that if you have any restrictions on hair or head coverings, that they be updated accordingly to be in compliance, with these new rules.
Yes, there was a quote from Governor Shapiro that hair-based racial discrimination has been a source of many complaints. And it was actually noting that there were more than 900 in 2022 alone. So
right, right.
The purpose behind this.
Right. And as we've seen, the Crown Act really, like you said, Carrie, it has expanded across much of the country at this point. So hopefully everyone who's listening today has at least had some exposure to it. It's a good law to have in place. And certainly, while safety is always a concern and we want to take safety first when we are dealing with our employees. We also want to make sure that they are not discriminated against based on their hair or their hairstyles. So that is what we have on the WARN Act for Pennsylvania. Talk to us about weapon
Yes.
notification.
So there's been a weapon notification requirement that is implemented for schools. It's a statewide requirement, and it is effective as of January 6th. So the requirement specifically requires schools to notify parents, guardians, and school employees when a weapon is found to be on school property at school-sponsored events or on school transportation. The notification is required within 24 hours of the incident. And important here is it applies to not just public schools, but non-public and private schools. So for those purposes, it's really any, an evaluation of what a school is and the definition therein. It really applies to all schools. Notification should not include any personally identifying information, however. So the student, any personally identifying information about the student is precluded from that notification, except in the specific situation of identifying the student and the incident-related school records to the school employee responsible for that student. So that's really important here, is that obviously the teacher or the educator is aware of who the child or student is. Right. So weapon is also, it's not specifically defined in the legislation, but the legislation instead refers back to portions of other legislation where it does attempt to define weapon, but it's certainly not limited to these definitions. The obvious ones here would be a knife, cutting instrument, cutting tool, firearm, shotgun, rifle, etc. But again, it's not limited to these. And then school property is also broadly defined as school grounds, any transportation used by the school, or any location where a school-sponsored activity is conducted. Again, field trips, locations of field trips, etc., like we discussed, parks, things of that nature.
Right.
So.
Right, and we do have plenty of clients who are private schools or charter schools, and so we want them to be in the know on this one. But also, we have clients that do have school-sponsored events at their locations, and we want them to be in the know about this as well.
Yes.
All right, so what about Philadelphia's new Ban the Box? And this one, I think, as well, is kind of hopefully a lot of people are familiar with Ban the Box because it's been trending for a number of years, and a lot of different states have enacted one. So Philadelphia, what is going on there?
So under their Fair Criminal Records Screening Standards ordinance, they have made some changes effective January 6th of this year, and it does apply to all employers, to both current employees as well as applicants for employment with those employers. And what this one does is it really limits the look back period for misdemeanor convictions from that traditional 7 years that's in a background check to 4 years. It also statutorily bars employers from considering what are deemed minor offenses, those that don't rise to the level of either a misdemeanor or a felony. Sometimes they're called local ordinance violations, things like that, disorderly conduct, loitering, petty theft. So those are barred from consideration. Now, also, expunged or sealed records cannot be considered, even if they somehow surface. Sometimes things come up in a background check that aren't necessarily asked for, if you will. But if it does surface, an employer will be required to provide written notice of its decision and identifying the specific, if they do surface, they must give the opportunity to the applicant or the employee to give evidence of the expungement or sealing. So again, that's important there because they can't be considered, but if they do come up, certainly employers need to give the applicant the opportunity to provide, evidence of the expungement. They also have to give notice of the intent to perform the background check. And then overall, in general, if an adverse employment action is determined as a result of a background check, an employer will be required to give written notice of its decision, identifying the specific conviction considered, and provide the applicant or current employee with a copy of the criminal record used in the decision. So there's also directions that are necessary on how the applicant can provide additional insight into whatever is deemed, found in the record and deemed a part of that employment decision. So there's a number of things that are addressed here, but most notably, it's the look back period for misdemeanors.
Right. All right, what about Pittsburgh? They have enhanced their paid sick leave rules. So again, we
Yes.
have, in this case, another city who is making some changes. So effective this month, there is the Paid Sick Days Act. This applies to all employers employing at least one person in the city limits, regardless of the employer's physical location. So in a nutshell, you have someone working in Pittsburgh, make sure you know about this. It requires employers to allow employees to accrue paid sick time and use it for specific reasons. So I think interestingly enough, what the law has done is instead of accruing 1 hour for every 35 hours worked, they'll be accruing 1 hour for every 30 hours worked. So that I think is more in line with how most employers have, or most states and localities have drafted their laws. Additionally, employers with 15 or more employees, employees may earn up to 72 hours of sick leave per year, which is up from 40 hours. And employers with 15 or fewer employees are going from 24 hours to 48. So we're seeing really almost a doubling of time for a lot of employers, and definitely that increase there of paid sick leave. So, this is in effect now. And so you want to make sure that if you have policies impacting your Pittsburgh employees in place, that they are updated and that you are accruing time accurately and in compliance with the law. So moving on, because we only have 10 minutes left. Rhode Island, real quick, we have some minimum wage updates. This year, minimum wage is now $16 an hour. Next year, it will be $17 an hour. Vermont is seeing from last year at a 14.01 per hour to now this year at a 14.42 per hour. And for tipped minimum wage, we have 7.01 an hour. Now it is 7.21 an hour. So just some little updates for Vermont. And then now let's talk about our case law updates. So Carrie, walk us through the 11th Circuit's ruling reinforcing
Yes.
convincing
So the
Mosaic
11th
standard.
This one's entitled 11th Circuit's ruling reinforces convincing Mosaic standard. The 11th Circuit is the district that covers Florida, Georgia, and Alabama. And we want to start off with just explaining why this is important, because while the ruling is guiding in that particular district, it's also very persuasive in other districts, which means other parts of the country will look to this particular ruling for guidance, if you will, when these particular cases come up. So this case rejects the rigid burden shifting test that was under the McDonnell-Douglas analysis, and it rather favors the totality of circumstances approach in discrimination cases. So it's a December 5 of 2025 ruling that the 11th Circuit's viewpoint that discrimination cases should be viewed from a totality of the circumstances approach is really important. So it really could, basically it's saying that the employer, the legitimate business reason alone may not be enough to dismiss claims early, which means more will be proceeding to trial. So it's going from having just that the employer saying, hey, it's a legitimate business reason for this particular practice, rather than saying it's based in discrimination, to moving to the totality of circumstances. So moving past just the legitimate business reason, now the court's going to consider the totality of what's being presented to them, and which again may get many cases past that summary judgment phase. So once past the summary judgment phase, from a litigation standpoint, many more of these cases are anticipated to proceed to trial. So again, it's persuasive authority across the nation. And the emphasis here really for employers is consistency in employee treatment, maintaining strong documentation, and providing regular training and policy updates. Those are the real takeaways, because under the totality of circumstance approach, an employer providing a legitimate business reason for an adverse action taken against an employee bringing claims of discrimination will most likely no longer be sufficient to have that lawsuit dismissed. So again, it's called the convincing Mosaic standard at this point.
And this is going to be, I think, one of our hot topics for the year ahead, to see how this plays out in both the 11th Circuit, if it gets appealed up, and also what the impact is going to be in other circuits. like in the Northeast. So there's also been a lot of independent contractor misclassification challenges. So I think the thing to keep in mind here is that even though the current administration has taken the prior rule that was in place in 2024 and really gone for a more employer friendly rule at this point, please keep in mind that the 2024 rule, which was really more worker friendly, looking at the totality of the circumstances, which we kind of just talked about, test is going to remain in effect when it comes to private litigation. And so that means that your plaintiff's attorneys are still going to be relying on that test to be able to assert that an employer has misclassified an independent contractor. And so we have a couple of cases here. I won't go through each of them, but I think on a high level, I think it's just a good reminder that there is still a lot of active litigation out there for independent contractors. There's been a lot of success for a lot of these cases that have been brought. These ones are still, still pending. However, ultimately, they can cost employers a lot of money. So just remember, if it looks like a duck, quacks like a duck, it is a duck. Please make sure you're properly classifying the individuals who are doing work for you, because these cases, like the one at the bottom, the car one, can result in multi-plaintiff FLSA class and collective actions, which ultimately can really end up costing employers quite a bit of money. And then in New York, Carrie, what is happening with ADA cases?
So, as we know, ADA cases have been under particular scrutiny lately because of the emphasis on the interactive process in evaluating ADA cases. So we highlight this one because this is twofold. It was a January 2nd, 2026 decision out of the U.S. District Court for the Southern District of New York that ruled that denial of an employee's request to continue working remotely as a disability accommodation was not sufficient to constitute disability discrimination. But it's important to note that the ruling underscores the importance, like I said, of that interactive process in accommodating employees and clarifies the difference between proving a failure to accommodate a claim versus failure to accommodate a claim versus a discrimination claim, if you will. So again, the court's decision affirmed that the failure to accommodate alone is not an adverse employment action. An employment action supporting a disability discrimination claim must be based on an employee's disability, and the ruling again emphasized that interactive importance, or excuse me, the interactive process, if you will. But again, I state that because it's in the context of the retaliation claim is where that denial of the continued remote work comes in. So again, there's a number of different factors here, but it really does emphasize the importance of that interactive process.
Right. Yep. You don't have to give the employee everything that they demand all the time, but you do need to engage in that process. And that is step one to protecting your company. So when we talk about litigation trends, I think just to highlight again, retaliation is a claim that really gets a lot of traction, even if an underlying discrimination or harassment, claim really doesn't go anywhere. A lot of times it's what the employer does after the claim is made or the complaint is brought that really comes back to, hurt the employer. And that's the retaliation. So we've seen a rise in retaliation claims, but we've also seen a rise in race, disability, and sex discrimination. Also, we've seen an uptick in ADA and disability accommodations, as well. Religious accommodations are still low, but certainly keep, that in mind. We want to make sure that we're complying with, applicable laws. One thing to highlight, the Pregnant Workers Fairness Act has been around for a few years now, and there has been a drastic increase in the number of charges that have been brought under that act. So if you have pregnant employees, just understand that they have this additional protection. And so it's really important to be very careful how you navigate it because there's a lot of claims out there now for pregnant workers. And then New York specifically has seen an uptick in litigation for things like uniform maintenance pay, meal credits, documenting meals and wage and hour claims, including claims about overtime. So those are some things to be on the lookout for. And then just to kind of do a little final hot topics, things to keep in mind. Carrie,
Really quickly, yes.
really quickly.
Really quickly, I know we have, we're going to keep an eye on state responses to federal trends. So we have a federal trending one way, many states are trending another. We're going to see that in representation in AI legislation. I think we just had the New York RAISE Act that's being considered, the OSHA enforcement at a state level versus a federal level, things of that nature, immigration enforcement trends, and then certainly the paid sick leave trend you've been discussing.
Right, for sure. And pay transparency continues to be a hot topic across the states. So at this time, I'm going to hand it back over to Carrie. Thank you all for your attention on today's webinar.
Thank you both, Liz and Carrie, for this informative presentation. And to everybody who joined us today, the next webinar in our series will be on February 11th and will target the Southeast Coast. So keep an eye out for an invite. A recording of this webinar will be available on our website shortly at prestigepeo.com/webinars. If you have any further questions, feel free to contact your human resource business partner for further assistance. And stay updated on compliance alerts by visiting our compliance center, prestigepeo.com/compliance-updates. And don't forget to check your inbox for our monthly Insights newsletter delivering the latest HR news. Thank you all, and we look forward to seeing you next time.